Hi, I'm Murray Johnson. Every time I attend a condominium function or an educational seminar, I hear the same thing. That the number one dispute between condominium boards and owners is all about access to records. What are these crazy records that everybody wants, and why aren't they getting access to them? There tends to be an us and them attitude toward this. Now, I suspect it's because boards are saying, what are those owners looking for? And owners are saying, what's the board trying to hide? Let's see if we can work through this today, if we can. Today I'm joined by Patrick Greco. Patrick, thank you for joining us. You're with the firm of Miller Thompson. Perfect that we have a lawyer here to help us with this today. First of all, what are these records that owners can view?
Sure, Murray. You're going to look to two places to see what records an owner can look at, and that's going to be the Condominium Act and the records contained or listed in the bylaws of the corporation. And an owner is entitled to view those records for purposes reasonably connected to the Act. Traditionally, that was scrutinized somewhat by the board or by management, but the case law has evolved to the point where the courts have said a condominium's records are an open book to an owner. That's subject to three exemptions. The first is employment records, so where you have something like a superintendent. An owner can look at the employment contract, but nothing beyond that for the purposes of privacy, such as performance evaluations. The second are records pertaining to a unit. And again, that's for privacy. Condominiums are a community, and if everyone was looking at everyone else's records all the time, it could get interesting. Mm-hmm. The third are items pertaining to pending or actual litigation, and that's to preserve solicitor-client privilege, litigation strategy, and could pertain to communication with the lawyer, but also records to do with the actual subject matter.
Well, thanks for that. I mean, we now sort of had an idea of what the records are, and specifically those that owners shouldn't be able to see, and I think it makes sense. And usually when we tell owners that they understand. But why do you think there's such a reluctance by the board to want to produce records?
I think it could be one of two things, and the first is where the corporation just doesn't have the records. That could be because of sloppy record keeping or multiple management changes, and these records have just disappeared. The best thing to do in that circumstance is just come clean, be open and honest with the owner that these records don't exist and here's what we do have to offer you. The second is where corporations and boards are scared of the troublemaker owner who's on what we call a fishing expedition, and that's where a request has come in for years and years of records. It's not fair to instantly assume that that's the case, but a lot of times it is. A corporation should be able to produce the past year or so of records in fairly short order and fairly quickly. If the request goes further back, it could take some more time, and key there is communicating it to the requesting owner, saying, here's how long we think it's going to take, here's when you can expect these records. What an owner cannot expect, and what is not fair, is to have a bunch of questions answered about those records. So a lot of times you'll have an owner look at some records and then say, okay, why'd you spend this money? Why'd you pick this contractor? And many, many more questions. Those are not a record of the corporation, and a board of directors who are already volunteers shouldn't be put to the time to answering those nonstop questions. Those are for the AGM.
Now that makes a lot of sense, and I guess that can cause a lot of hard feelings when
Exactly.
they feel like they have to defend themselves. So I get it, and I understand how boards might be reluctant to give these records because it feels like you're giving the enemy ammunition. Right. And in a situation where that does happen, what recourse do the requesters have if they don't get the records?
Right. Well, in the vast majority of situations, Murray, we encourage a corporation to produce records that are even remotely producible or that an owner has the right to look at. The reason is they're going to come out anyway. If they are producible, they're going to come out, and it's probably going to be before the court, and the corporation's going to look worse for it. So take the example of, say, a report pertaining to mold, where there's been allegations and perhaps even a threat to sue the corporation. A corporation may hear litigation and say, well, we don't have to produce that. It's going to come out eventually, and it's going to look worse when it does. That's not to say a corporation can't push back at some point and say enough is enough. these requests are repetitive or too broad, and we feel we've fulfilled our duty. And if an owner feels that they've been wronged, or if appropriate production has not been made, depending on your jurisdiction, the owner may be able to bring a small claims court action or some other kind of regulatory application to get those records and to have some decision maker determine whether more should be produced.
Interesting. I can see the disconnect now, it can get problematic here. I guess the fishing trip that you mentioned is when you're starting to monopolize the board time and the management time for your unit alone. It becomes unfair to the others.
That's right.
The debate continues. Thanks for that, Patrick.
Thank you.
Hopefully today this little discussion helped you understand a little bit about some of the contentious issues around requests for records. Until next time, I'm Murray Johnson, and this has been your Condo Connection.